There we go. Okay, now we're recording. Glad I reminded myself. So again, everybody's muted. That helps us reduce noise and distraction. If you want to rename yourself, you can. Questions, comments, or resources, please share those in the chat room. And Christina and I will kind of keep track of that. And I think the attorneys are going to be able to see that as well. So we'll try and pass those questions along as time permits. And today, actually, this the second to last bullet here, we're going to be doing 5 sections of the 7 we started out with, and hopefully we'll get through all of those. And then the advanced session next Tuesday, we're going to be pretty wide-ranging and open-ended with questions and answers in that section. So I think that's going to be a great one to take part in if you have specific questions you want to have answered. Okay, here are our attorneys today. You'll get to know them a little bit. There's not much that goes on in fair housing in this state or surrounding states that these two haven't encountered or don't know about. We've got a lot of expertise between the two of them. And then again, just a quick overview that the purpose behind the Fair Housing Act is really to increase economic opportunity for people and kind of level the playing field for folks, because where we live has a big impact on our access to essential community assets, clean air and water, all of those kinds of things. So that's something that we focused on with our analysis of impediments, or assessment of fair housing as it's now called. And so you can see a little bit more on that. Again, this information will be available on the link I shared in the chat room, so you can review this later. I'm going to try and get through this pretty quickly. You can kind of just glance at that. Like I said, we're trying to move forward as fast as we can to get through this 5 sections we've got today. And then if you have additional questions, I recommend this video, The Basics of the Fair Housing Act, presented by Christina Miller. It's a really in-depth, detailed presentation of a lot of the basics. These guys are going to talk about some of the intermediate stuff, and again, some other links there you can take advantage of. I encourage you to visit fairhousingforum.org and idahohousing.com/fair-housing for more information. Okay. So now I'm going to switch gears here and get started with Eric.
Thanks, folks. Thank you, Eric. My name is Eric Stephen. I'm an attorney in Spokane, Washington. I practice in every county east of the Cascade Mountains in Washington and northern Idaho. I'm going to be working today with David Penny out of the Boise area, talking to you about a number of fair housing concepts. And we're going to do this in a pragmatic manner that talks about the application of fair housing to various aspects of landlord-tenant relations. Last week, we covered an overview of the concepts and protected classes. We talked about advertising last week. Today, we're going to talk about tenant screening. We're going to talk about developing non-discriminatory rules. We're going to talk about enforcing rules in a non-discriminatory manner. We're going to talk about protecting against discrimination with your policies and practices and some suggestions there. And then we're going to talk about what to do when you find one of your agents has engaged in discrimination or you've been charged with housing discrimination. So today we're going to talk at first about tenant screening. And I think it's really critical that you be on your game, so to speak, relative to tenant screening. There's been a lot going on with respect to tenant screening over the last couple of years. And it's an area that I see a lot of actions filed against landlords in. And I think a lot of it's landlords failing to understand some of the basic ground rules that govern tenant screening. Like all areas of fair housing, I think that David would also tell you that your documents and your record keeping is really critical. And I look at your tenant screening criteria as a sword and a shield, as I do almost all your written documents. The documents, if they're organized and appropriate, give you the ability to seek affirmative relief to get your needs met. The documents, if they're in order, provide exculpatory evidence as to why you made the business decisions that you made. And why those decisions were reasonable and appropriate and not discriminatory. So first thing I want to tell you is you need to have a written screening criteria, and the screening criteria should be posted on your websites and available in your offices. The screening criteria should be provided to all of the applicants. And I really don't, we need to go to the next slide, Eric. I don't have control of it for some reason. I think it's a really bad idea to screen clients and applicants over the telephone without providing them a written screening criteria. I think it's a really bad idea to advise applicants that they don't need to apply or query them on the telephone about their rental history or their criminal history, and then advise them that there's no need to apply and to save their money. I think it's a really bad idea. I think you should be providing the application to everybody, and then screening any applicant who provides you with an application. The screening criteria should pertain to past rental history, the applicant's credit history, their bankruptcy history, and their criminal conviction history. You need to be mindful of the Fair Credit Reporting Act, and I'm going to talk about that in a little bit more detail, what you need to do under that. You need to be mindful of the HUD guidance memo from April 4th, 2016 that relates to criminal conviction screening. And I suggest that you have your head on a swivel and be open to some new ideas and theories of recovery, such as source of income discrimination issues, and I'll talk about that in greater detail. The screening criteria should inform the applicant of the grounds for denial of the application, and it should inform and it should be applied uniformly to all applicants. There's been a lot of talk around the country, and especially in my state, Washington, my home state, about first in time and the need to grant the first applicant that meets your criteria. I believe that's the best practices to avoid housing complaints. At the same time, I know a lot of landlords would prefer to pick the applicant they think is the best suited for their property. I don't encourage that. I don't look at applications as holding a deck of cards. I prefer for clients to date and time stamp applications when received to ensure that they avoid discrimination claims. Next slide, please.
Let me just jump in for a minute there, Eric. And
Hey,
I would mention, even if you do have that criteria, and I agree with everything Eric said, it's one of the reasons why you don't want to screen people over the phone, or you want to avoid potential applicants hitting you with hypothetical questions about, well, would I qualify? Here's my situation. And there you are, you don't have a full application in front of you. The person may not have told you all of their facts and all of their information, but they're hitting you with a hypothetical question. Maybe the calls come and interrupted you from something else you're doing, and your mind's not fully in the application process. So whether you have that criteria, which you absolutely should or not, you do definitely want to avoid working on hypothetical questions that you're asked over the phone. You can write down information, get back to someone, but it's rarely a good idea to talk to a potential applicant and give them your off-the-cuff view of whether they should or shouldn't apply. Everybody should be welcome to apply. Anything you say that could potentially dissuade them because you're answering a hypothetical is, well, you're in difficult territory and should be avoided.
Good points, David. I think we've both seen a number of situations where somebody calls in and says, hey, I've got a dog. Is that going to be okay? And the landlord says, oh, no, we're a no pets property. And then the person says, well, I'm in a wheelchair. Does that matter? Or something like that. And I've just seen a lot of hypotheticals like David talked about in the screening process where somebody sort of gets the ball in play. I can also tell you that the testers from the fair housing claim facilitating agencies will frequently give you kind of half a glass of information and just see how you respond to it and kind of set you up for an additional call later on to see if you change your tone. And sometimes, half the time, the clients don't even understand what they've told the person on the phone and how it's going to be used against them. So
occupancy policy is another place where you'll get, well, it can be testers, but then also just potential applicants want to find out. And you don't have a complete picture of the relationships of all the people, their birth dates, their ages, and depending upon your occupancy policy, you could be giving them an answer that's imperfect because you have imperfect information. So you can always write information down and get back to somebody, but you should always invite them to apply. And that's the bottom line.
Right. So one of the next things I want to talk to you about is you have an absolute duty under federal law to provide what's called an adverse action notice if you conditionally accept an applicant or deny him. And a conditional acceptance occurs when you require a co-signer or maybe you double the deposit or something along those lines. I still see a lot of people that don't issue their adverse action notices, and that's a violation of the Fair Credit Reporting Act at the federal level, folks. So we need to make sure that you're doing it a lot. I think there's a lot of confusion frequently between the client, landlord, owner, and the tenant screening agency about who's going to send or issue the adverse action notice. And if you don't know what an adverse action notice is, you should. It's a document that applies in any application for credit scenario for the most part. It applies in housing applications. And the content of the document is dictated by federal law, which we'll talk about in a minute. You need to make sure that you avoid steering, and we talked about steering quite a bit. David talked about it in the introduction section. It's not up to you to decide the best property for the applicant to live in. The applicant's applying for a property. I like my clients to advertise their properties online and let the property speak for itself. You don't need to be telling the applicant where they'd be better off living, and you need to be careful about that. Anything you want to interject there, David?
No, I just think that here again, we kind of came up with a simple rule that advertise the attributes of the property, not who you're looking for.
Next thing I have in here is keep track and document the criminal activity in the area where your leasehold's situated to allow screening for such activity. And I'll talk to you about that in greater detail under the April 4th, 2016 HUD guidance on criminal conviction screening. But I think it's really important for you to be able to preserve information about criminal activity that's directly in your area. You need to establish safeguards for the screening process. And I make sure that all my clients' applications give them the ability to stop the screening process if the applicant is belligerent, hostile, or threatening. I always want my applications to contain language that an incomplete application cannot be accepted or will not be accepted. I want my applications to talk about refusal to accept an application from somebody that appears obviously impaired or intoxicated by alcohol or drugs. They don't have capacity. And I believe you should always make your applications subject to penalties of perjury, and make sure that there is some sort of oath on the application indicating that it's truthful and accurate. Those are some of the procedural safeguards that you need to protect yourself in the application process. David?
No, I think that's all good. I don't have anything to add to that.
You should establish a review process for denied applications, especially as it relates to criminal conviction screening. You need to keep good records of all your inquiries and applications. I actually had a client call me a couple weeks ago. He had somebody leave a telephone message on his answering machine, and he didn't get back to him, and the person called him up later on and said, "I'm going to sue you for housing discrimination because you didn't return my call." But you need to keep track of all your applications that you've received, and any information provided for applicants should probably be preserved as well. Keep track of all your adverse action notices. If you get sued by HUD or the Human Rights Commission later on, all your documents and your record keeping can really work as providing you great exculpatory documentation if you're doing this stuff right. So really important to keep your screening materials, applications received, and your adverse action notice is issued, even though these aren't necessarily formal clients that you're going to be dealing with in the future. Use third-party screening service is my recommendation. I know a lot of landlords like to do their own screening. I don't recommend it. I'd rather defer that out. Understand most of the screening service providers that I see have little language in their contracts and their documents that indicate that it's actually the owner landlord making the screening determination based on a recommendation from the screening provider and screening service. Lots of people think that it's the screening service that makes the determination. And I pretty much assure you that if you look at your agreements and your contracts and your notices, that it's that the screening agency has set that up so that you are the one as the owner landlord that's making that screening determination. And then finally, develop a waiting list policy so that you keep track of who's applied when. And I think that goes into your best practices of accepting the first in time qualified applicant. Dave, what are your thoughts on first in time?
Well, I think that's definitely the safest, and it is a best practice because you've set your criteria, and if you've set it correctly, then a person qualifies. You shouldn't be making what could be a purely subjective call then on who's better or who you think might be better. It leads you down the wrong path. I know that it's taught broadly that your first qualified applicant is the person that you work with first, and if they don't take the apartment or whatever, then you move to the second. And so there's a sense of fairness to that as well that makes it a good business practice and protects you. And of course, that ties in with the wait list policy. Being fair and taking the first qualified applicant.
I think that if you do anything other than that, you're really engaging in a subjective assessment of the applicants, and you're taking that one step further from the objective criteria that David talked about. And now you're applying a subjective set of criteria. Anytime you get into that subjective set of criteria, it's going to open the door for somebody to say that you're using an inappropriate criteria to select an applicant over theirs that was first in time or prior in time. David, can you talk a little bit about identifying applicants? And that's the next slide.
Identifying applicants. Well, certainly the issue that and the question you often get from people is use of identification and use of a social security number. And the bottom line is that a social security number is a very appropriate bit of information to obtain as part of your application process and part of your background investigation of applicants. The important part here is that you need to ask for the social security number from everybody. Regardless of criteria, no exceptions, get the social security number. If you ask for it just from people who are of a particular national origin, then you're treating them differently, subjecting them to different scrutiny, and there'd be a potential for a fair housing violation there.
So if you have an applicant that is of a foreign national origin, I think you need to consider accepting some other alternative forms of identification. And we've got a list of those that I'll go over in just a second, but I think the next slide is more of David's stuff.
So yeah, here 18 and over, you can certainly require valid identification. And here again, we're going to eventually get to the list of acceptable forms of ID. There are a number of them. Generally, children under 18 aren't going to have those forms of identification. So it's not a practical requirement. And then you need to be ready to work with people. If they don't have a particular form of identification, and accept something as long as it's reliable. I mean, at the end of the day, it's to obtain identification that you can rely upon as true. So go to the next slide.
Hey, before we go on, David, what are your thoughts on screening minors and stuff? And, you know, it's a real bugaboo for me when you have a delinquent minor that gets in and he's got a substantial criminal history of minor offenses and stuff. What do you tell clients relative to screening applicants under age 18?
Well, typically the advice is that you don't do it. And there's not a practical, efficient way of doing it. You'd be making a family incur another application fee if you were using a formal screening group to screen a child. Is there some risk of a delinquent individual who causes problem? There are some risks, but here again, you're going to have the rules that we're going to talk about, and you're going to enforce those rules. So you're not without any remedy in that particular situation.
Thank you, David. I think that's pretty good advice. I think screening minors is problematic. If you were going to do it, you'd want to do it to all kids over like 15 or something like that across the board. You wouldn't want to just isolate certain families that had what you perceive to be a delinquent child as candidates. I think it's a problematic area. The next slide that's on the screen, guys, is just a list of some alternative forms of identification: driver's license, U.S. passports, passport cards, DHS, trusted traveler cards such as 9 Global, Entry, Nexus, Century, and Fast. I'm not familiar with a lot of those, but they're apparently travel cards. U.S. military ID, permanent resident cards, DHS designated enhanced driver's license would work. Airline or airport approved ID if issued under TSA approved security plan. Tribal issued photo ID, HSPD 12 PIV card, foreign government issued passports, Canadian driver's license, and it says Indian or Northern Affairs Canada card, or transportation worker identification credentials. Washington just recently passed laws where we can't discriminate in Washington for citizenship or immigration status. So those type of theories, they're right next door to you guys in Idaho. Dave and I have talked a little bit about the different postures of Washington and Idaho. Washington's extremely liberal, very progressive in how they look at new theories of liability and fair housing and otherwise. Idaho seems to be more conservative in that bent. But, you know, I think that concepts of fair housing violations are going to continue to expand for some time. And I think immigration and citizenship status, I think stuff like source of income status, those are potential areas where you can get tagged, and you got to be smart about it because those theories of recovery are coming to your area, and I don't think you're going to get the toothpaste back in the tube real quick. We've had some change in HUD relative to service and assistance animals, and we've seen a digression there where service animals used to be dogs and miniature horses. Now it's just dogs. That's one area of the law where it's digressed, and the toothpaste has gone back into the tube a little bit, but I don't think that's going to be the predominant trend. I think it's the other way around.
Yeah, I would just mention that certainly in Idaho, you can require someone who is applying to be in the country legally. So, you know, Washington, I'm not familiar with everything that's been adopted in Washington, but in Idaho, you can require proof that the person is in the country legally. It relates to their ability to be a reliable tenant in your property, to be able to live there for the full amount of the term. So I think that's the way it is in Idaho. And while Washington does have the prohibition against income source discrimination in Idaho. That state law does not exist here as of yet. If Eric's right, it may be coming someday, but as of now, there's not a federal or a state statute on that.
Gentlemen, we got a question in the chat regarding screening, I believe, and it says we need to note that we still have to check sex offender registry for most minors, at least at HUD Section 8 properties. Is that something you're familiar with?
Yeah, I think you have a prohibition against allowing sex offenders, but that's part of your criminal history screening. I suppose you could have an application that asks if any household member is a registered sex offender.
Okay, got it. And we are at 12:31 now, and
go to the next slide.
We're ready to go to the next slide. Okay.
So one of the things you need, next slide. One of the things you need to be sensitive to is what you can screen for. Back one, Eric. What you can screen, no, forward. Under the Fair Credit Reporting Act, which is at 15 USC 1681C. This statute, federal statute, applies to all the screening in the United States, and it limits how far back in time you can look. And it uses the word antedate report, which means preceding the report, the screening report that you're looking at. It allows you to look back at bankruptcies that antedate the report for 10 years, civil suits and judgments that antedate the report by 7 years, or the expiration of the statute of limitations. In Washington, our judgments, civil judgments, are good for 10 years. They can be renewed for another 10 years and be viable for 20 years. So when you looked at a screening criteria, you might think that, oh, well, that one's already expired, but it might actually have a longer limitations of action period. Paid tax liens that antedate the report by 7 years, accounts and collection that antedate the report by 7 years, and any other adverse item of information that you're going to weigh in the application process can't be more than 7 years old for you to evaluate that as a potential hit or miss on your screening criteria. So really important on how far back in time you're looking at information, and you would not want to deny somebody's application because they had a bunch of accounts that were in collection, but those collection activities were over 10 years old or over 7 years old in that situation.
I would just say, hopefully your third-party screener is on top of these laws and developments, and so they're not including this information in your report, which is another reason that it's often good to use a third-party screener.
Good point. And I think that you really need to look at and evaluate your screening criteria, or your screening consumer credit reporting agency that you're working with, or screening agency. They're not all created equal. Some are very good, some are not. And even some of the bigger ones aren't really strong. What I see in Washington is a lot of them don't appreciate the distinctions between federal and state law. Not a big deal in Idaho, where your state law mirrors the federal law quite a bit, but in other jurisdictions it can be a big deal. And I think, like any other vendor in the industry, some are much better than others, and some are much worse than others. Next slide. So on April 4th, 2016, HUD dropped a big bomb on the industry. And what they did is they gave us a guidance memo on disparate impact in evaluating criminal conviction records. And you really need to read the HUD guidance memo, in my opinion. It's such an important document. But what it talks about is your screening criteria under the Fair Housing Act when you are evaluating somebody's criminal conviction history. And what they say is that people of color are arrested at disproportionate rates, that we have a large percentage of our populace that has been incarcerated, that there are barriers to reentry in society when people are released after serving jail time or prison time, and that those people that have served jail and prison time get reintroduced into our society and they can't find housing, in large part because of barriers that have been established against them. And that those barriers frequently fall on people of color more than people of Caucasian. So what they've done is they've developed a 3-step analysis for evaluation of your screening criteria and practices. And what I'm going to do now is, next slide, is I'm going to talk to you a little bit about the 3-step process and what you have to do to screen for criminal conviction history in a legitimate way, and what's going to get you into hot water. It says the first step of the process is for the plaintiff to prove that you have a criminal history screening policy that has discriminatory effects based on a disparate impact analysis. And what they say is that the plaintiff, in that case, HUD or a private lawyer, can use national statistical data that's already loaded up to say that people of color are arrested at disproportionate rates. And those statistics will essentially make the original first step of the case against you. The document talks about how you should introduce evidence from your local statistics of the proportion of people of color being arrested and the proportion of people of Caucasian race being arrested. And if you don't introduce your own local statistical data, that's when they'll default to the federal data, unless it's proven to be totally not in line with your local data. In determining whether or not a policy or practice is discriminatory under disparate impact analysis, it's going to be a fact-specific and a case-specific inquiry. The next slide, please. The second step of the analysis is for the landlord housing provider to prove that, or to announce that their practice has a legitimate, justified purpose. And it's been, HUD recognizes that providing safe properties to others is a legitimate, justified purpose for this, but then goes on to say that bold generalizations and stereotypes that only individuals with an arrest or conviction pose a greater risk than those without a arrest or a conviction is not sufficient. So you cannot just rest on the premise statement that people that have been incarcerated constitute a direct threat to person or property or an unreasonable risk. You can't rely on those hypotheticals. The materials go on to say that if you are evaluating arrests and not just convictions, that is not going to meet HUD's criteria, that you cannot show that the mere arrest of somebody is significant or that person constitutes an unreasonable risk. And why they say that arrests aren't indicative of conviction. And in fact, the materials say that in most situations, evidence of a conviction will serve as sufficient evidence that the person engaged in the criminal conduct, which is kind of mind-boggling, folks. HUD's telling you that, well, if the person's convicted of the criminal act that's on their criminal history, then that's pretty good evidence they engaged in that conduct, but it's still not everything. And it says, but the housing provider must still be able to prove that such policy or practice is necessary to achieve a substantial, legitimate, non-discriminatory interest. And it says that a housing provider that imposes a blanket prohibition on people with convictions won't meet the HUD standard. So if you have a screening criteria that is, we will not accept anybody with a felony conviction, or we will not accept anybody that has 3 misdemeanor convictions, those type of criteria are going to get you in hot water because they're blanket prohibitions that apply across the board. It says that a housing provider must show that their policy or practice accurately distinguishes between criminal conduct that constitutes a demonstrable risk to resident safety or property and criminal conduct that doesn't. And what they mean by that is you can screen for criminal convictions on criminal conduct that poses an unreasonable risk to the health or safety of property. Serious crimes against person or property, rape, murder, homicide. There's a whole list that I'll go into in a minute of serious crimes, but you better not be screening for driving without a valid operator's license or more benign crimes. And I would even say probably DUI and or DWI and some other driving crimes, and then just little petty crimes HUD is going to say that if you're denying applications because of petty criminal conviction conduct, that you don't meet their substantial, legitimate, non-discriminatory interest hurdles. So really important there. And to get past the hypothetical and speculative nature of the criminal conduct that we talked about in the second step, that's why I always stress to my clients that they want to keep evidence of the criminal activity that's been occasioned in the area of the property. Guys like David and I see all sorts of criminal activity all the time, just on the wealth of our experience with all these different properties. But I don't think the landlord gets to share my experience. I think the landlord has to say, hey, we've experienced this type of criminal activity in our area, and we preserved records that there really is this activity going on in our area. And as a result, we believe it's necessary to screen for that type of criminal conviction history in our area to make sure it's not proliferating. And that would be stuff like vehicle prowling, stalking, and some of those other crimes that you might want to try to bring into this. One of the things I've gotten some feedback from the Washington Attorney General's office was on arson cases and fire cases and reckless burning cases. And I had an AG tell me that they didn't think our screening criteria, which was vetted through Zoanne Olson at Intermountain, as well as Marley Hockendeiner at Northwest Fair Housing, and an AG tell me they didn't think our criteria was acceptable because I thought it was because they thought the screening of crimes was too liberal. So I think it's really important to have evidence of the criminal activity around your property if you're going to screen for that type of criminal activity. David, do you want to talk about anything here real quick?
I just throw in I think you mentioned it, but to emphasize that it doesn't matter that in Eric's analysis that you had no intent to discriminate, you didn't mean to, or that you apply your, we don't rent to felons criteria equally to everybody without regard to national origin, race, or what have you, because just the nature of what we're talking about isn't disparate treatment, which is, directed at that, let's say, an applicant, and specifically, we're talking about disparate impact, having a facially neutral rule or policy, even when you apply it to everybody, just because the nature of here our criminal justice system and certain races of people, they're impacted more than others. It has a disparate impact on them. So you really have to get into this statistical analysis, which is where no one wants to go. I still run across people who say, well, we don't allow felons at our property. And that is not a criteria you can have. You can grade the felonies and have, a felony within a certain time period that you don't allow. You can figure into that, think about, that there's going to be a period of incarceration and a period out of incarceration, and what's a reasonable time frame that person might not be allowed to, or might not qualify as an applicant under the law. But that blanket no felons doesn't work. The only two blankets I'm aware of are registered sex offenders. You can have an absolute policy that they don't qualify, and people who have been convicted of manufacturing and distributing drugs. You can have an absolute blanket no to them as well.
Thanks, David. And the materials do talk about how this guidance memo is all about disparate impact, and that landlords can still be sued for disparate treatment, like David talked about. The third step, let's go to the next slide. The third step is for after the landlord shows that they have a legitimate, justified business purpose and necessity for engaging in their screening criteria, the burden shifts back to the plaintiff HUD or the private lawyer for the applicant to indicate that such an interest of the landlord could be served by an alternative purpose. And the materials talk about an individualized assessment of mitigating factors is likely a better chance of meeting the HUD thresholds. And what they want you to look at is when the applicant was convicted, the duration of time since that conviction, any good tenant rental history before or after the conviction or the conduct that was engaged in, the nature and severity of the conduct, any rehabilitation, treatment, or other mitigating factors, restitution, any kind of individualized assessment that shows that the applicant is not a continuing risk. Now, I had one of these cases right after the HUD guidance memo came out. I almost thought it was a tester, but the person had a bunch of convictions, burglaries, residential burglary stuff, and some other pretty serious felony crimes. And then it was accompanied by a letter from a counselor that said, this guy is such a great guy. He is so reformed. I am so excited about his prospects for the future and stuff. And it goes on, and he said, in the 2 hours that I've been acquainted with so-and-so here, he has just convinced me that he is no longer a direct threat or an unreasonable risk, and his application should be accepted. And then I look back at the guy's criteria, and he had 3 convictions that were 3 years old, and then 1 conviction that was about 7 months old. And we denied that application without any problem, because there wasn't a history of good tenant conduct. But you need to, in your analysis here, you need to be taking notes and making sure that you make distinctions between why somebody is not a risk, even though they have a criminal history, or why somebody is a continuing risk, even though they have a criminal history. Because later on, you want to keep records of all these documents, and if you get sued for this type of violation in your screening and lease-ups, you'll be able to show, hey, listen, this applicant was denied because he's an unreasonable or she's an unreasonable risk. We accepted these other applicants that had criminal convictions. We don't have a carte blanche, no felon policy here. We thought this person was an unreasonable risk. That's going to be a safe harbor for you in a lot of situations if you've done your record keeping right.
The other thing I would just add to that is you should always have an ability for someone who's denied on criminal background to appeal. I mean, it should really be anybody denied in your screening process, but certainly in this area, it's important for them to appeal. We talk about treating everybody the same, and that's good, but there is a point in time where you have to look at people as individuals. Then information may not come out on your criminal screening that they present that could be important for you to consider. So there always needs to be a basis for them to appeal and for you to take a second look.
Great point there, David. And I said that at the beginning of the materials that we do want you to review these criteria. And I think especially with the HUD guidance memo on criminal conviction screening, the materials talk about how you want to make the assessment of criminal conviction history as your final assessment after you've already looked at rental history and credit history. Easier to say than do. I haven't seen anybody that compartmentalizes the screening process like that, but that's what the government thinks. But I think all of David's sentiments are right on point. And the next slide, please, is a sample screening criteria.
Gentlemen, we've got a quick question before we move on. Somebody asked about, what about a person that spent 31 years in the state prison and was just released in 2017? How do you interpret that? And we're almost at our
right, well, somebody that spent 31 years in prison doesn't have a lot of real good tenant history afterwards if they've just recently applied. And I think you still have to look at the nature and severity of their crime. And if it was second-degree manslaughter or something like that, then they might still be an unreasonable risk, in my opinion. But there's a lot of other mitigating factors that you don't want to look at there. And as David said, the meeting with the tenant is going to be where you flex your muscle and show that you have an individualized assessment. When this first came out, I was talking to a bunch of claim facilitators like Marley Hawkendana from Northwest Fair Housing Alliance and Zoanne Olson from Intermountain. And we were all pulling our hair out saying, well, we're supposed to do these screening in an objective format, but then this screening criteria says, oh, no, you start by screening objectively, then you got to be real subjective. And that's where you're going to get into hot water, is the subjective aspect of it, unless you do it in a good way and really document what your subjective assessments are. So
we got a follow up on that, and it says, can you ask about a letter from a parole or probation officer with a long-term relationship with the applicant? Is that something you'd recommend for violent offense?
So what I do is I have my clients indicate to the person, hey, we need more information about your criminal conviction history. Please provide us information of any mitigating factors. So I think that a letter from a parole officer or somebody that's had a relationship with the person, that's going to be one element of the documentation that you review to make your assessment. David?
Yeah, I mean, what immediately comes to mind there is you apply your criteria first. And your information that you give someone you've denied has an adverse action letter that tells them your appeal process, they decide to appeal, that's the place where, coming with a letter from someone from a parole board or additional information like that might make a difference in a close case.
So the next slide that's up there right now, don't go forward, we're using this slide, Eric. This is a criminal history screening criteria that I developed, that I had vetted with Zoanne Olson at Intermountain and Boise, as well as Marley. They all approved on this. This is the document that the Washington AG gave me some resistance to. The first paragraph of the document announces your intent and what you're screening for. And I've tried to maximize all the different reasons that you would screen. So you're screening to with the intent of maximizing the ability to provide safe housing for residents, managerial staff, property, and neighbors. Screening criteria intended to minimize liability risks, costs of insurance, maintenance, and repairs to property, and shall be designed to provide housing to individuals who do not constitute or pose an unreasonable risk of direct threat to persons or property. And they agree to limit screening criteria to only serious offenses. I go on and I announce a number of serious offenses: murder, manslaughter, assault, robbery, rape of a child, rape, child molestation, lewd conduct. I guarantee you lewd conduct was one that the AG would have taken me to task on, but I see naked, or I hear about naked people in front of bay windows all the time at multifamily housing complexes. So I think that's a problem. Solicitation of a minor for immoral purpose might have been one the AG would resist. Registration of for federal sex offender, kidnapping, theft, first, second, third degree theft, identity theft. That's one that might be a problem area for you. Prostitution, burglary, malicious mischief, arson, reckless burning, delivery controlled substance, possession controlled substance, manufacturing. Then the materials talk about the mitigating factors. And then in criminal conviction history cases, that will consider the nature and severity of past conduct, age of the individual at the time of the conduct, evidence of good tenant history before or after the conviction or conduct, rehabilitation, treatment, restitution, nature and severity of offenses, number of past similar offenses or lack thereof, and impact of housing decision on non-offending members. So that's some of the mitigating factors. And then I've got another section that's very aggressive on this, folks, that talks about people with pending criminal cases having those applications stayed and not processed until the criminal case is finalized. That's fairly aggressive, folks. And I haven't provided this document for you to use. I provided this document for you as an example. You should vet this document with your own private lawyer. But that last paragraph, when I created, because there are certain situations where the pending cases are so bad, you've got somebody with 3 arson cases that are pending in court, and you were looking at them, they don't have a conviction, and I needed to have something to tell clients as a potential tool for that. I think it's aggressive. I think it may get you into hot water, but I wanted to give you at least a sample tool on how to delay potential evaluation when somebody has really, really significant criminal case pending in the court during their application process.
You know, somebody who from the past was arrested and the legal proceeding is over and they didn't plead guilty, they weren't convicted, they didn't plead withheld judgment or something of that nature, then I think that's off the board. But if somebody has a criminal case that's pending, I think it's right for you to ask more questions. And you certainly have a right, you know, what occurred, where, you know, what type of crime is it? You can dig into that more deeply to see, you know, what the conduct was. So I think you can get into that. If someone committed murder the day before they come to apply for your apartment complex, it would be ludicrous to say that you can't consider the facts surrounding that, even though they've been charged and not convicted. You certainly can. But I think the big takeaway from there is you just can't draw conclusions from the fact of a charge in the past or a current charge. It's not the same as a conviction, but it doesn't mean you have to ignore it either.
It makes a great point there, because what he's talking about is it's not the fact that you were arrested, it's the fact that you engaged in the conduct. And the Fair Housing Act does not provide insulation to people that constitute a direct threat to persons or property if the risk can't be mitigated. And I think if you dwelled on the conduct and not the arrest in that situation, you would be in a decent position to sustain your actions. Let's go to the next slide real quick. Source of income. I want to talk about this just real briefly. We have as a Washington law now. The reason I'm talking about it for you isn't because it's a law in Washington and we're your neighbor. The reason I'm talking about it to you is there was a case in Yonkers, New York, that's about 15 to 18 years old, where a landlord refused to accept a housing choice voucher, denied the applicant, saying, "We don't take Section 8. And the landlord ended up getting sued, and they were sued for disability discrimination and refusing to accept Section 8 because the analysis was that more people on Section 8 are protected immediate the familial class protections or the color or disability protections than others folks, and that there was a disparate impact by the landlord's rule of not accepting Section 8 housing voucher recipients. That type of argument is essentially a common law disparate impact argument. Disparate impact's been tightened up a little bit, but it's still one that could be made in a lot of different contexts. So that's why I get on my soapbox to talk about that. In Washington, when we advise our clients on source of income or screening for income, we make our income to rent quantifiers based on the tenant's portion of rent. So if I have a client that says you have to have 3 times the amount of rent as income to qualify, we say you have to have 3 times the tenant's portion of rent as income to qualify. And that gets us past that source of income analysis. Next slide. We're going to talk now briefly about developing non-discriminatory rules. And I think it's important that you provide the tenant, next slide, with a core set of basic rules that apply to all tenants. Post the rules at the office. You want your rules to be observable. Set limits that are reasonable. And if they're based on realistic, not exaggerated health or safety concerns, I have folks ask me all the time, do you think this rule or lease covenant's reasonable? And I always think, if you have to ask me if it's reasonable, then there's a good chance it's not. And I would always suggest that you look at it and say, what would you think if your conduct was governed by that rule? Rules should address behavior, not status. Rules should not be so restrictive that families with children do not get equal use or benefit of the housing. Rules that target or specifically are directed at children are likely to be problematic. You don't want teen curfews and that type of thing, or teen loitering rules. You can have curfews, you can have loitering rules, but you don't want them directed at minor kids. Know all your protected class statuses and make sure your rules aren't designed and directed at protected class. And know what's discriminatory. Discriminatory conduct is disparate treatment, treating people differently because of their protected class status, or disparate impact, which is a facially neutral rule which has a discriminatory effect in its application. Next slide. You want to avoid unintentional violations, adult swim hours. You can have a lap swim hour, but you can't have an adult swim hour because it discriminates against families with children. You can have a curfew, like I said, you just can't have a teen curfew. You can have a no pet clause, but you can't say no animals, and treating service animals or support animals like pets is a pretty easy way to fall into a violation. You want to create clear, comprehensive, written, neutral rules that address conduct, not character, kind of like what David was talking about before. The rules should address what will happen when violations occur, address serious violations that endanger others, such as drugs, assaults, and destruction of property. I think it's really, really, really important that your lease covenants and rules address harassment and belligerent conduct. I have real comprehensive conduct covenants that I use that talk about all sorts of different conduct that causes disturbance of the peace, including conduct that's designed to invite a violent response. Use of racial epithets and that type of thing. You need to address repeated minor violations as being a material violation. I want you to consider policies of progressive discipline, which means that you're going to attempt to get compliance by issuing comply or vacate notices before you try to terminate a tenancy or issue a notice to quit. And just develop a policy that you're going to use to work through your rule violations. And that should be how your rules are laid out. Your rules should be adequately communicated to the tenant, which is why we talked about posting and going over them, making sure your leases are legible. You might have to translate leases in certain situations. We talked about limited access plans and limited English proficiency last week. We had Jim Haynes opine on some of that and make some clarifications for us. Jim gave us some really great information after our session was over about LAP, limited access plans, and limited English proficiency. But you may need to apply that, especially in your affordable housing portfolios, subsidized housing portfolios. David, what would you like to add about developing non-discriminatory rules?
One of the keys certainly is to make sure that your lease incorporates your rules into it. And we're going to get into enforcement in a moment, but that's an important point, is to make sure whatever rules you've adopted, your lease refers to them and makes them part of your lease.
David, don't you think you can accomplish that by having the rules signed and dated by the tenant?
You can, but I often think it's good to do both, quite frankly. And a lot of landlords do, although you can end up with a relatively long, extensive list of rules depending on the property and property amenities. So I think it's important to have it incorporated into and made part of your lease. Simple, better, direct, and to the point. If you look at your rules after today and you do have references to children and their conduct, I encourage people, look at your rules and see, could you just drop the word children out and put in the word occupants?
Household members.
Because, I leave my bicycle on the sidewalk all the time too. Somebody could trip over that. So it's not correct to have a rule that says children won't do something. It needs to say occupants, to include adults. Everybody who lives there is subject to the same rules. So, if you do have a swimming pool, I would just, mentioned that you can talk to health departments. You can check and see what your municipalities do with their pools as far as rules, an age at which someone needs to be accompanied by an adult. Because there are a lot of people, maybe 13, 14, 15 years old that could swim laps around all the rest of us. So, very often look and find out what is the guidance that they're living by and try and be consistent. Use those as information in adapting your own policy. A rule that says children or everyone under the age of 18 must be accompanied by an adult member of their household at the swimming pool is probably discriminatory. Certainly a 7-year-old sibling can take a 9 and 12-year-old sibling to the pool and should be able to. Yeah.
Great points, David. And I think those ideas also apply to your community centers, your fitness centers, and those type of things. I see lots of rules that say nobody under 16 to be allowed in the fitness room or something like that. I tend to encourage people to supervise at those places at certain ages that are real young, and I usually have the rules defer to the manufacturer's policies and recommendations for use of equipment. But you got to be really careful when you start imposing age restrictions on different parts of the community that are going to be used by your tenants. Let's go to the next slide. We're going to talk now about enforcing rules in a non-discriminatory manner. First thing I want you to do is keep activity logs. I always tell my clients, keep a general activity ledger that is just sort of about everything that's going on at the property, anything that gets your attention. I also want each tenant file to have an activity log about what's going on relative to that family. I want you to discover, document, and investigate alleged rule violations. Unsupervised, somebody asked about unsupervised children. I don't look at it as unsupervised children. I look at it as what are the children doing that's in derogation of tenant duties. So if the children are throwing rocks against cars, then they're throwing rocks against household members, causing damage to property of others, or engaging in malicious mischief and that type of thing. I don't want to say that you're failing to properly supervise your kids. And as David talked about before, I like to use terms like occupants and household members, not only when I'm drafting rules, but when I'm drafting notices of rule noncompliance. And I think it's really important that you avoid conclusory statements and conclusory labels in your notices of rule violations. Just talk about the conduct and talk about it being a household member or guest. But I don't think it's a good idea. You can even reference the person's name, but I don't think you want to say you're failing to supervise your kids. You might think that's the reason this is happening, but talk about what the kids are doing when they're not supervised and how that's a problem, I think. Would you agree with that, David?
I would. Yeah, I think that's sound advice.
Okay. So when you get an allegation of a rule violation, first thing I want you to do is write down who told you what, when, and what they said. And then I want you to always solicit a written statement from that person who's making the allegation. And I always tell my clients, tell the complaining neighbor that you want to enforce the rules, but you want to know exactly what's going on. And that if it means something to them, then they should be willing to put it in writing. And you need to understand that you may have to produce these statements at some point in time, especially if you go to hearing or try to evict the tenants, and that there's not really, I really get sick and tired of people that say, I'm going to make this complaint, but I don't want you to disclose who I am or let them know I made the complaint. I think you need to marshal the troops in these situations and let the complaining neighbor know that, hey, I appreciate your concerns. I'm going to act on your concerns. I'm going to make this part of the record here, and we're going to take action as we can. We may need to use you as a witness later on. And if they say, well, I don't want to be involved, then you say, well, I can only, enforce this to the extent that you're willing to support it, because you are the witness, not me. You as the manager are not really the witness unless you've got personal knowledge of the situation. And when you draft your note, preserve evidence or information. If there's ever any kind of condition that can be documented through photographs, always do that. Issue your written notices authorized by state law. Identify all the policies that have been violated in your lease, rules, or statutes as a result of the conduct, and be really specific and particular and describing the tenant conduct. I get tenant advocates always taking up running for you. I get tenant advocates frequently challenging cause eviction cases, and I do a ton of cause eviction cases. But tenant advocates always say that the notice lacked the specificity to allow my client to understand what happened and when. So I always want my clients to, in their notice, describe what happened, when, where, and how it happened. And I want you to keep third-party witness statements or complaints that corroborate that you took action and issued that notice based on the evidence and the information provided to you by the neighboring tenant. There are going to be some times where you investigate and find out those allegations aren't true. But if you investigate and you can't prove the allegations aren't true, then I think you frequently need to act. And in those situations, I think you need to describe with particularity the conduct that's been engaged in. Rules about marijuana use. I try to govern or police marijuana use with no smoking policies. That's one of your, and also drug-free housing policies, that type of thing. I think that's your easiest way to do it. If you allow smoking, then I think you're going to get stuck in some situations with marijuana. I know Idaho still hasn't recognized recreational marijuana like Washington and some of the other states. You've got a better chance of enforcing it over in Idaho. But I think your no smoking policies, including no vaping and preclusion of incense and those type of things, are probably good tools for that. Anything you want to address right now, Dave?
Yeah, one of the things that I would mention when investigating a violation, typically one that would come from a complaint by another resident, is to make sure to investigate equally and talk to both sides. So often I'll find out, or have in the past found out, that the manager took the complaint by the complaining person and issued a notice of lease violation, for example. But really the best process, unless you have some other basis to verify it, would be to go and get the other side of the story. It's often very important. It shows that you're being fair, you're not judging it. And then the other thing I would say that certainly for minor lease violations, it's important to have a progressive kind of warning system. If you don't already, I'd advise people in management capacities to have a notice of lease violation. It's not a legal document as required by Idaho law, but it's a notice to the resident, typically of a minor violation. I mean, the ones we always deal with: noise, guests staying too long, smoking, parking violations, those types of things. But it should cite to the provision of the rules in the lease that are being violated and say, you're violating this. You can come talk to us about it, but you need to be aware that lease violations can result in termination of your tenancy. You give that, you give it a second time. Very often people say third strike. And then, at that point in time, we're going to take legal action. The other good thing about that notice is that you've collected information and data. You've got a record of dates, what occurred, and that the person's been warned that their conduct's a lease violation, all of which would help you if you have to take the unfortunate step of going to court. Last thing I would mention is tenant-on-tenant harassment or rules violations. And just those are some of the most difficult that managers deal with. And certainly in that situation, you have to take good notes, investigate both sides, treat everybody fairly, and particularly look is one harassing the other because they're a member of a protected class? Is it race-based persecution of somebody on your property by damaging a car or stomping on the ceiling on their floor that happens to be the ceiling of the other person's apartment? And so you have to look at those and certainly have very low tolerance, if any, for such a thing. And then I just here again lastly mentioned severe violations, acts of violence, threats of violence, damage to property, intentional persecution of someone can certainly be exceptions to your progressive development of a case. And maybe there's not a 3 strike, maybe it's 1 strike and you're out because you have to protect your other residents.
Points, David. Somebody asked about uniformly applying the policies to all offending parties. You really cannot selectively enforce rules. That's going to get you into a disparate treatment situation. I always want to make sure if we're going to issue notices because of a condition of somebody's balcony, we better be issuing that notice to everybody that has too much stuff on their balcony or a defective condition that's similar. And just got to make sure you're across the board in your enforcement tools and processes. Dave's points are all real good and well taken. Understand the need to grant reasonable accommodations in terms and conditions at times. Why not move the smoke? We've had a lot of questions about marijuana smoking, and even if you didn't have a smoke-free housing property, if the smoke's migrating into another unit, it might constitute a nuisance. It might be an actionable offense. I think if it's drug activity in Idaho, it's going to be drug activity in Idaho, and your 6-303 is pretty good, strong statute for drug use. Somebody asked for a reasonable accommodation for marijuana. The feds won't give that. It's a controlled substance, Class A controlled substance under the Uniform Controlled Substance Act. So my understanding is that you can't have a reasonable accommodation to allow marijuana use, even if it's medicinal marijuana at this juncture. That may change depending on federal legislation. So reconcile your lease to follow federal, state, municipal rules and regulations. And then the next statute is all about accommodations. And I think this is you, David.
Yep, it is. So let me go back to one other thing, though. I saw a question. Somebody asked, what do I do? I have a woman who is a resident who smokes in her unit and says that she can't ambulate or otherwise leave her apartment to go smoke outside. Do I have to give her an accommodation? And I'm bringing that because we're headed into reasonable accommodations here. And I would say, no, you don't have to do it. That's not a reasonable request. The secondhand smoke, firsthand smoke, damage to the unit, these are all severe impacts upon the properties and your other residents that come from a resident smoking. So that would not be, go ahead, Eric.
Yeah, I was just going to ask you, David, do you think you'd ever get a healthcare provider to say that his client needed to smoke more cigarettes and there was a nexus to allow them to smoke more?
It wouldn't surprise me, but I think it'd be very rare. Let's put it that way. But anyway, so I wanted to grab that question real quick. Everybody should be acquainted with reasonable accommodations. And I'm going to move through these slides quickly. You can read them. They should just be, oh yeah, I remember that. And certainly what we're talking about here is it only applies in disability issues. I'll sometimes get people asking whether they need to reasonably accommodate someone based upon national origin. And of course, the answer is no. That's a different topic. reasonable accommodation is only a concept in disability. And the accommodation must be necessary because of the disability, and it must be necessary to give the person the opportunity to fully enjoy and use their housing. Go on to the next slide. Everyone should have at least an outline idea of the process. You should recall that a person with a disability can request an accommodation either verbally or in writing. You might have a form. They don't have to use your form. You can fill your form out with their information if you want to. And then it's up to the housing provider, gets a chance to verify in some situations anyway, whether they have a disability and whether there's a nexus between the disability and their housing. It's always important to keep in mind that if the disability is observable as a disability, then you can't seek verification of the disability. If the need is also observable, then there's no verification at all. Person is a resident or has applied to be a resident and they have a seeing eye dog and they bring the seeing eye dog to the office. That doesn't need verification. On the other hand, you might have somebody who has the need for a comfort animal. There's nothing observable as far as their having a disability or their need, then of course you could verify it. Qualified professional does the verification, and we're going to get into that a little bit here with some recent guidance.
Let me interject something real quick if I could. We just had on January 28th, 2020, HUD released a FHEO 2020-101 related to assessment of reasonable accommodations for service or support animals. That document echoes what David was just talking about landlord. It says that it is to be applied to other reasonable accommodations. It's germane to what David's talking about right now for a couple of reasons. One is it clarifies that you are not allowed to ask for additional verification when the tenant's disability status is obvious or regarded. And you're not allowed to ask for verification when the nexus between the accommodation requested is obvious or apparent. So those are real important. It's real important that you familiarize yourself with the FHEO 2020-01 released on January 28, 2020. That document also talks about qualified professionals that can verify an accommodation, and it's much more restrictive than what we had been hearing from the tenant advocates in the past about who can verify a disability and reasonable accommodation request. And I believe the FHEO 2020-01 would tell you that has to be a professional licensed healthcare provider, physician's assistant, nurse practitioner, those type of things. But I think it removes other people like social workers, clergy members, and some other people that would not be characterized as professional healthcare providers from the list of folks that could document and verify an accommodation request. Your thoughts on that, David?
Well, I'm going to get into that guidance here in quite a bit of detail, all consistent with what Eric just said. Last point on this slide is that in verifying information, you can't request the medical records or ask about the disability. So let's go to the next slide. Okay, so before we get into developing procedures, one of the things I do want to talk about is the guidance and what we learned in January 2020, and also just to make a plug for HUD guidance. There's HUD guidance on a wide range of topics when it comes to housing, all of which is available online and should be read. Certainly if you're if this is your occupation or profession. Now, the guidance that came out focuses mainly on requests for accommodations for assistance animals and is broken down in two parts. It is how to assess a person whose request is to have an animal as a reasonable accommodation. And part 2 is documenting an individual's need for assistance animals. And these are the 2 big areas where there's a lot of conflict. Well, while the guidance is about accommodations based upon animals, there was a lot of questions answered that apply uniformly across requests for accommodations of any kind, whether it be for a parking space or an exception to any other type of rule. The first is we're told in this guidance that 10 days from receipt of the information is a reasonable time for a response. There've been a lot of HUD complaints filed because people think it should be shorter, quicker. The landlord took too long in responding. And we should also know that if you don't respond or take too long, that's considered a denial. So how much time you have has always been an important question. This guidance seems to indicate that if you do it within 10 days, it's reasonable. We've also had the issue of internet-generated verifications, where the person, I think we've all seen these, a certificate from some group claiming that they can determine or give you a license or permission to have an assistance animal or support animal where you live, and they give a vest and a tag and all these things. And there are varying degrees there, but this guidance says that the internet generated verifications alone are not enough. So what do you do when the resident comes and says, I need to have my cat as a comfort animal, and here's the document that I got from the National Association of Comfort Animals and my certificate? Don't dispense with that, but you have a right to ask for more. You have a right to ask for that a medical professional with knowledge of this individual has given the opinion that they have the disability and the need for the animal. So another issue is that a lot of people, and I've seen these and for a while, I think it's perfectly acceptable, the verification pages had the medical professional verifying under penalty of perjury. And the guidance here says that's no longer proper. You can't require that the verification be notarized. What you can require is that the verifier be either a healthcare provider or a disability specialist. That's the language that's used. And they must have personal knowledge of the patient client. You can require them to attest that their information in the verification is accurate to the best of their personal knowledge, consistent with professional obligations. Yeah, Eric?
I just want to make the clarification that that's a subtle distinction that you're making there, David. It's the tenant requesting the accommodation that can have to make the request or verifications under some sort of oath of truth and accuracy, not the healthcare provider like you mentioned before.
Yep. The other thing is confidentiality. The guidance is clear that this whole process, any information, even though you're not supposed to receive medical information or medical records or nature of disability from the tenant, regardless, whatever you do receive within those bounds is still confidential. I think we touched on this last time. The example I gave was the manager's out walking the property and a tenant comes up and says, you told me I couldn't have an animal, couldn't have my dog as a pet, but yet the folks in unit 203 have a dog. Why is that? The manager breaches confidentiality if they say, oh, well, Mrs. Jones has a disability, and so she's allowed to have that animal. because you've just revealed something about her health. The correct answer is we apply the rules fairly across the board to everybody, and she's allowed. That's all the person's entitled to. Yeah, Eric.
I was just going to talk about, somebody made a question as to how do you request the verification, and I'm sure, David, you're going to get into the two parts. You've already mentioned there are two parts to the HUD FHEO 2020-01. The first part is for the landlord to use. The second part is a document to be provided to the tenant on the type of information that they can proffer to verify the accommodation request. You might want to get into that here for a minute.
Yeah, I got two more points on this. One is the guidance says never deny a request for lack of information without giving the person a second chance to get you what you need. Very often it will be incomplete. It will not be from someone who's a qualified verifier. And so you look at it and say, well, this isn't sufficient for me to approve this application. They're saying the correct step is to get in touch with that resident, probably in writing, and say, I still don't have the information. This is what's missing. I want to give you another chance to provide it to me. When you do, I'll certainly consider it.
And then you provide the second part of the document of the FHEO, which tells the tenant what information will work as a verification. Correct, David?
Yeah, well, certainly you can. The guidance even suggests that's one of its purposes, or the correct step, is if the person seeking approval from you is missing the boat, or their provider, health provider or disability specialist isn't hitting the target with what you need, that you give them the second part of the guidance, which can be printed off. They can take it to their provider, and that tells them what to do. What we're talking about here at the end, or when either you don't have information or you would otherwise be in a position where you might deny a request, is to engage in the interactive process, which is mentioned here at the end of this slide. And that is, you got to be willing to talk, consider a different information, or consider a different accommodation. Someone might be seeking an accommodation that you can't grant in the way that they've requested it, but you have an idea of something else that perhaps might work. And so the interactive process is for you to put it out there and see if something can be worked out, an accommodation that meets their need and also would meet your approval. So yeah, the next step really is what documentation. This has been another area of frustration for the housing provider, the person seeking the accommodation, as well as the person who's providing their verification. You must consider the request if an animal is already on site. Even if there's a lease violation, or even if you're in the process of an eviction for them having an animal, you still have to consider their request and what they might provide to you. So you can have more than one. Yeah, go ahead.
David, I think it's important to clarify your last point, which is if you start a termination of tenancy or an eviction for an unauthorized animal, and during that process, the tenant provides verification of disability status and nexus to support the use of that animal as either a service or a support animal, then the FHEO 2020-01 says you have to stop the process of eviction or termination and accept that animal as a qualified accommodation. You can't just say, oh, they screwed up by bringing the animal in early and without authorization. Don't you think that's correct, David?
Yeah, I think that's correct. That's the point there, is that you have to, right up to the end, I guess they can seek and comply with the requirements for verification. So the documentation, the burden is on the person seeking the accommodation.
Next slide, Eric.
To provide the verification. So it's on them to do this. And so if you have your form, you can offer them your verification form to use. They don't have to use your particular form. They can use a letter. They can use a prescription. Sometimes you'll see matters written on a prescription that would be sufficient documentation. But here again, depending on what you're verifying, if you're verifying that the person has a disability because it's not otherwise obvious, that information has to be provided. Usually a verification form will, from a management company, will have the definition of what is, unfortunately they use the term handicap, but what is that definition under the law so that the healthcare provider can provide it. And then the information provided has to establish that nexus, that because of their disability, they need this accommodation in order to enjoy and make use of their housing. And then it has to be from somebody who knows them, has knowledge of the person seeking the accommodation. And Eric was correct in what he said, that who this person is, that standard seems to have been raised in this guidance to someone with some ability or training to recognize what is a disability. That's often what they're seeking when they say healthcare provider or disability specialist. It's someone who can look at a condition, look at the definition of disability, and apply those to provide that type of information. The last thing I was going to touch on is unique animals. This guidance also talks about animals that are beyond your typical household pet and what is required, and recognizes that there's a higher level really of verification that can be required by the housing provider. You can seek verification of why this particular type of animal is the accommodation that's needed. Maybe come up with an example, an exotic animal. The person wants to keep a kangaroo in their unit. You can ask for verification of why the kangaroo is necessary to meet the need for this person seeking the accommodation. And you can ask whether the healthcare provider has relevant information about that specific animal, and when was the last consultation between that verifying party and the party requesting. I think I mentioned this, but just to make sure that the guidance is clear also that a person can have more than one assistance animal in the household. So I think most people are aware of that now. And that's, as you apply reasonable accommodation rules and laws, that's something that you should be aware of. Yeah, Eric.
We got a couple of questions. One of them was if you were terminating a tenancy because an unauthorized dog was causing damage to the property, would you have to stop for the accommodation? I think that goes to your notice to quit or notice to terminate tenancy, and how supportive that was with allegations of the animal causing damage. And in some situations that may survive, and others it may not. There were a couple other questions. One was, geez, Eric, you want to replay those or tell us? I think I saw three questions.
Sure. We got a couple of them here.
Yeah.
One of them is just to me, and it says we've got a 32 unit that's taken over, that they've just taken over, and all the tenants have expired leases and are not willing to sign the new lease. They, because they want to have new rules imposed there. Previous management let them do whatever they want. We're trying to get the property under control. How do we do this if they won't?
I would give them notice of change in rules, and I would incorporate the new preferred lease terms into the rule change notice with great particularity in how I draft the notice and making sure I can prove that how I serve the notice on everybody to constitute a new valid rule.
Yeah, so maybe even get some legal advice or counsel on that might be good.
I'll reach out to
And then you've got one that says if an assistance animal is damaging the property, can an eviction
that was the question I just answered.
You kind of addressed that, I mean, yeah. And then
certainly the bottom line there is yes. I mean, if even if you don't, you should have a set of rules applicable to pets if you allow them, and a set of different rules to assistance animals, because you're going to have to allow some, and those should be based upon, protecting the property, protecting other residents. There are a number we can think of, cleaning up after the animal, but all of those should require that if somebody has an animal that's damaging the property, then that's a lease violation. Even if you don't have that, and a resident, if your lease just says the resident will not damage the property and their dog's damaging it, well, the tenant's violating the lease with their dog damaging it. And so whether that dog is an assistance animal or whatever is irrelevant, because the tenant cannot damage the property. And so you could certainly proceed forward and enforce the lease.
And then finally, there was a question about a letter to verify a disability and a nexus between the disability and accommodation. It says the management company has their own letter, but if the tenant brings a letter from a doctor, that's adequate to have an assistance animal. Without the letter, the company creates.
Yes.
Correct? I think you mentioned that earlier.
You have to, you can require that verification be in writing if it's a matter that you should verify. You can require the verification be in writing, but you have to be willing to take other written documents other than your form.
My new letters for accommodations predominantly provide the tenant requesting the accommodation with the second part of FHEO 2020-01, which is the documentation necessary to support accommodation requests. I think that's one of the requirements of FHEO 2020-01. I think your form letters should be vetted again to make sure they meet the new HUD guidance. And even if that relates to accommodations other than assistance or service animals. So I think it's an area that you got to look into. David's right. You can't insist on the verification form being in any type of specific format, but I think the forms that the landlord's using really need to be revisited at this time and weighed against 2020-01, the FHEO.
And I'll just share one issue. I have a friend that I hike with periodically who's blind and uses a guide dog, and she just shared with me that when the last time they renewed their lease on the house they rent, the property manager charged her an extra $1,000 for a pet deposit. And she was not aware that that was a violation of the Fair Housing Act. She's aware now. But stuff like that does happen. And anyway, so yeah, I think beware. And I think that the thing that I always come back to is when you're talking reasonable accommodation or modification, the key word there is reasonable. And we're at 15 minutes out, so we've got 15 minutes left, guys.
Yeah, so given that we're 15 minutes out, we'll spend a significant amount of time on reasonable accommodations. If this is a new area for you, you've got Christine Miller's HUD training on it. If it's not, and you're interested in these points that Eric and I have raised about this guidance that came out in January, by all means, go online, find it and read it. Last few points I want to make was that, a company should do certain things to help protect itself. This is actually a slide before it, but I'll just mention it. Develop a written accommodation request procedure. Keep it simple, 8 steps for what you're going to do. So it's also training your staff as well as telling someone what you're going to do when they apply. Have compliant forms if they want to use them. Designate an experienced individual within the company to oversee the accommodation request process and make determinations. You need to centralize that as opposed to have it dispersed. And then incorporate an interactive process in accommodations. We've talked about that. I'll just quickly mention modifications. There's not much difference between modifications and requests for accommodations, depending on really who pays for them. You can use the same forms. Often you'll have different forms, but you approach the modification the same way. One of the big difference you'll find is that if you are in subsidized housing, Section 504 of the Rehabilitation Act of 1973, I think it is, applies and places the requirement on the landlord to pay for the reasonable modification, whereas conventional housing, the tenant pays for it. In both settings, though, or certainly in the setting where the tenant is paying for it, the landlord can require that the property at the end of the tenancy be restored to its prior original condition. And last, to answer a question that often comes up, what do you do with guests? You have a resident with a disability, you have their guests who come who have disabilities and bring their assistance animals. Must you allow to bring them onto the property when they visit? And the short answer to that is yes, because they're an individual who's associated with an individual with a disability. And with that, I think we better move on to protecting against disability, or we'll run out.
Protecting against discrimination. So, place through this, I want you to develop internal protocols and policies addressing advertising, tenant screening, lease up, work orders, inspections, rule enforcement, and claims against management. I think you should educate and train your staff, train on both landlord-tenant law, local to your jurisdiction, and fair housing law. Understand limited English proficiency and language access plan. It says assessment plan. Jim Haynes clarified it's an access plan. Foster environments of inclusion. Post non-discrimination posters in your offices. Include written non-discrimination statements in your documents. Perform audits to ensure that your agents are acting properly. Both Zolan Olson and Intermountain and the Northwest Fair Housing Alliance will perform audits for you. Most of the time, they'll tell you what you're doing wrong without suing you, which is what you want. Consult with counsel early on if you think you might have a problem, especially a fair housing problem, and develop strategies for going into this stuff and looking through the case. Don't just, one of the things I can't stand is when clients have worked on a case for 3 months and then really entrenched their position, and then they come to me and say, get us out of this. And I'm like, well, you've already slammed down the river quite a long ways here. We're going to have a hard time getting back. So make fair housing part of your hiring practices. Interview prospective employees about fair housing. I had a client one time who had hired a mom and pop set of managers who I had seen get sued for familial status discrimination at 3 other properties before they were hired. And I cringed when they surfaced in my client's portfolio as new managers. So make sure you know who you're dealing with and get, be sound in your hiring practices. Train on fair housing and landlord tenant laws, as we talked about. Unless you have something to add, let's go to David. Let's go to dealing with discovered discrimination real quick.
I was just going to add the part about hiring, that not only training, but make fair housing part of your hiring with your staff. I mean, it's certainly a good criteria to find experienced people, and regardless, you should have a policy as far as people obtaining training right off the bat, because it's always a good refresher. And then making fair housing policy part of the hiring packet. That's all I would add.
Let's go to
I think a good rule of thumb there, you can always default to that Christina Miller Fair Housing Basics video as something for new hires.
Absolutely.
If you want something that's sort of a HUD approved training.
Absolutely.
Let's go to dealing with discovered discrimination real quick and go through this. When you find somebody has alleged discrimination, if it's one of your agents, I think the first thing to do, next slide, is go to your human resource director and talk to your human resource and employment attorneys, make sure they're on board. I really caution you against a knee-jerk reaction of immediately firing the manager who's alleged to engage in discrimination. A lot of times you'll find that person has a lot of knowledge about facts that have occurred in the property, and this person may be your only witness if the case goes on. So you want to preserve their testimony, and you want to make sure that you make any firing or release decisions appropriately. You might want to make those decisions further down the road. Understand that this person is, in most situations, your speaking agent and has your apparent authority to act for you. So firing the person won't just make everything go away. David, anything on that?
Well, I was just going to add, in addition to the information there on the slide, is if you discover discrimination, do make sure that there's no retaliation occurring, because it's come to you either informally from the person who feels discriminated against, or even if there's been a formal HUD complaint filed, or they've contacted an advocacy group. You got to make sure that no one is doubling down, so to speak, or retaliating against that person, because retaliation, as everyone should know, is a violation of the Fair Housing Act.
So when you get one of these cases, and I think David will echo this, be professional. If your lawyer is responding to a fair housing complaint, telling the Human Rights Commission officer or the HUD representative that they're going to lose their job and that they're incompetent, you probably have the wrong lawyer. These people are going to make or break your fate. I get a lot of no cause findings in these cases, but it's because I work the case up, I clarify the facts. I rarely have to provide legal briefing. I will in certain situations, but very narrow issues. Typically just clarifying the facts and showing that the facts are not as facts alleged, and that there's two sides to the story. Your documentation is going to be key in these cases. And when I've handled fair housing cases in the past, if I've ever gotten worried about my position, I always revert back to the hey, exculpatory evidence. What are my documents? What's the story that I can tell through my record keeping and my document preservation? And I always want to invite conciliation of fair housing claims early on before there's a cause finding, because after an investigator or a judge after an investigator makes a finding of cause, reasonable cause to believe discrimination occurred, your claimant has really bolstered their expectations of recovery, and you've lost your chance to conciliate the claim at a reasonable amount, because now you've got a lottery mentality going, saying, hey, I'm going to get all the money in the world. Really hard to get the case back into control. So I think conciliation has to be investigated or invited early on in the process. And the bottom line is, I win these cases, and I'm sure David wins these cases, with clarification of facts, not clarification of law. And it's your record keeping that helps you prove those facts.
That's absolutely true. You win these cases with your client's documents. That's how you tell your side of the story and bolster your side. Conciliation is just going to happen. The more you're in this business, or an attorney, the more they practice in the area, you're going to have those cases where the facts aren't with you regardless. And if you're concerned about that, then conciliation does provide an off-ramp to a procedure that doesn't get any better. Because if you get that cause finding, the person who filed the complaint can have the Department of Justice represent them before an administrative law judge proceeding, so that they then have an attorney to pursue their vindication and to pursue their damages. And so, I mean, that's one reason that if you don't have a good case, the off ramp. And then we talked about regardless of whether there's a cause or no cause determination at the administrative level, the person claiming discrimination can still file a lawsuit in federal court, thinking that HUD got it wrong and I'll be vindicated, or HUD got it right. And now I'm really bolstered because I've got a good finding from HUD, and I'm now encouraged to go to federal court because I want to recover damages. Yeah, Eric.
Great points. I think that marijuana use case is going to be the one that probably makes it up with a private lawyer. In my area, I've got a really aggressive civil litigator woman that I've been kind of waiting to bring a marijuana claim as a reasonable accommodation case just to rock the country. One of the things I like to tell people is it takes very few individuals to find an entity or a landlord liable for fair housing discrimination. It takes one person making the allegation of discrimination. It takes an investigator making a determination of reasonable cause, and arguably either an administrative law judge or a jury of your peers making the assessment and determination as a finder of fact that you've engaged in discrimination. And that can be as few as 3 people, or as many, or as few as maybe 14 or something like that. But it's not a lot of people. And if it's 3 people, it's just 3 like-minded individuals that think you've done something wrong. I was at a presentation several years ago where a lot of the folks in the audience didn't like what the HUD investigator was talking about. And in that situation, it was a tenant who had paid a pet fee, and then later a non-refundable pet fee, and then later had their animal verified as an assistance or support animal. And the question was, well, should the landlord refund the pet fee? And the investigator said yes, and everybody said no, that's wrong. That shouldn't be housing discrimination. One of my associate attorneys came back and told me about it, and I told the associate, isn't it incredible that this audience was bullying the investigator that may make their fate? And isn't it incredible that these people just think they can change the process by sort of browbeating the investigator? And once again, if your tact in defending these claims is to beat up the investigator on their credentials and their determinations, it's not a real good sound approach. That person has their own bias and animus and everything, but they also are a trained professional and they've been in this industry for a while. And like I said, it takes very few people to make a determination of discrimination. I had a case one time where I got a no cause finding, and then a year and a half later, the case was reopened and a cause finding was made. So I talked in the first presentation. That case went on for 9 years before we got out of the Court of Appeals, and cert was denied by the Supreme Court. Went on forever. It was hard to say we won any part of that case, even though we were vindicated by the Court of Appeals. It went on for way too long. So I always want to try to steer these things for conciliation, and I've been able to conciliate a lot of them for not a lot of money, and I've been able to get a lot of no cause findings because my clients postured their position reasonably.
You want to come across?
Well, gentlemen, we're right at 2. We're at 2 o'clock here, or right at the end of the 2-hour mark. I'm assuming you guys are willing to stay on for a little bit, and if anybody in the audience wants to stay on, happy to continue.
I might not be able to stay on, but I'm sure Eric would give the same answers. One of the things I was going to say is that we're kind of looking at next Tuesday as a time for people to bring all those questions that, you know, they've got now, jot them down, any that pop to mind between now and next Tuesday. And really, we were going to just open up to questions and dedicate the time we have next week to fully answer. But
That's a better idea.
That sounds great. I appreciate that. And I just want to point out that for those of you who need a certificate for today, Christina just put her contact information in the chat. You're welcome to send her an email and she will get a certificate to you post haste. And you're welcome to sign up for the next session, the final session for the fall, and let Christina know if you have questions about that.
They can get those questions to you and Christina, right, Eric?
Absolutely, yeah. They have. There's an option when they register. I think we can make sure we collect questions ahead of time and then submit those to you. So we'll make sure we do that in the next couple of days, so you have some time to, you know, cogitate on those questions and come up with some responses for next
even
week.
If you can't attend next week, you can submit your question. We'll work on it, hopefully get to all of them, and next week's going to be recorded. So you'd be able to go and look at the recording and there's your answer.
Absolutely. And Christina just posted the link for the final webinar, final session in the chat. And, you know, that's there. You can also go to the fairhousingforum.org site. I've posted links to both today and to next Tuesday's session there. If you can't find it anywhere else, or if you lose it, just remember fairhousingforum.org. And there's a ton of information there for providers, for advocates, for tenants, for local government. It's really it's not an advocacy oriented website. It's really just a clearinghouse of information on, you know, fair housing resources and issues. So feel free to take a look at that. I think that should be one of the first articles that pops up on the main page.
Sounds good.
So thank you very much, you guys. Always learn something from both of you. And thanks to everybody who hung in there. We're happy to have that much participation. We had a good turnout today. So appreciate everybody's time, and we'll look forward to dealing with this again next week, following up.
Thank you, Eric. Thank you, David.
Eric, thank you, guys.
Okay, take care, you both. Bye.